Hello and welcome to the Rogers Brief for March 17th, 2023. Happy St. Patrick's Day to all of those that celebrate. I'm Adam Rogers. Thank you for watching and thank you for listening. This week on the Rogers Brief, I'm going to talk a little bit about the upcoming Mass Casualty Commission report. There was a news article yesterday from CTV Atlantic about the upcoming report with some details on the length of the report. So I'll talk about that a little bit, a little reminder as well of my own report, a competing report I think it'll end up being, but we'll see. And then related to that is the latest decision from the provincial court, and this was related, it's called the CBC case. The CBC was the original applicant, trying to get the informations to obtain the search warrant documents on Gabriel Wortman, the killer's properties, released. Much of the information in those search warrants was redacted, blacked out, and so different media organizations were seeking to have those redactions unsealed in a sense. So I'll talk about that a little bit. Some other decisions this week from the Nova Scotia courts. It's an interesting one, a freedom of information case that Parker Donham, well-known Nova Scotian commentator, political commentator, but public thinker that has taken this case to court and have a decision from Justice Cody on that FOIPOP request. Interesting small claims court decision on dog breeding. You get some interesting cases every once in a while in the small claims court. Interesting one this week on the rights of different parties about once a dog is sold, if it can be then bred, and who has the right to decide if that dog is going to be neutered. So I'll talk about that a little bit. The fascinating area of riparian rights. Anybody know what that means? This is to do with cottages, with rights to access water, and so there was a dispute that came to a decision this week with Justice Arnold making a decision about competing wharves, rights to the water access in there, so I'll talk about that. And then finally, there was a letter, open letter written to the Minister of Canadian Heritage, Pablo Rodriguez, from different civil liberties organizations across Canada, including the Canadian Civil Liberties, British Columbia Civil Liberties Association, and others, about online regulation. And this is talking about planned regulation of online safety. So I'll close off with that. But first thing I want to get to is this the upcoming Mass Casualty Commission, Nova Scotia Mass Casualty Commission report. This report is going to be released on March 30th. That's been announced. It's going to be released live in Truro. And there's some managing of expectations going on. I'm not sure what generated this story in a sense, because there was a story on CTV News yesterday from Heidi Petracek that the Mass Casualty Commission report, the final report, was going to be between 2,000 and 3,000 pages long. Well, that's quite long. You know, War and Peace is 1,000 pages or so. This report, 2,000 to 3,000 pages. So why say anything at this point? The report's coming out in a couple of weeks' time. Well, first of all, that's quite a range, 2,000 to 3,000. This report is going to be released in 2 weeks' time, actually just less than 2 weeks, just under 2 weeks' time. One would think they would have a little bit of a better sense of how long this report is going to be. It did say in the report that there would be an executive summary, a shorter summary of the main recommendations. So, so question is, the executive summary hopefully would be in the a few hundred pages range or less, to give us a real sense of the highlights of the conclusions reached by the Mass Casualty Commission commissioners. But if they don't know if it's going to be closer to 2,000 or 3,000 pages, if there's that much editing still left to do, that raises some concerns or some questions as well. What I really think this news release is meant to do is prevent or at least undermine any immediate reaction or analysis to the report. I mean, as soon as this report comes out, it'll be released that day. People will be asked questions. What do you think of these recommendations? And of course, there's going to be criticism of the commission because there's been criticism throughout, and, you know, garbage in, garbage out in a sense. If the process that led to this report had so many flaws, well, one can expect that the report itself is also going to be flawed in a sense. We're anticipating that. We're going to give the commissioners an opportunity to write the report, release it, and convince us, persuade us that the recommendations they're making are appropriate given what we've all heard, and we've all heard the evidence. So it'll be very interesting to see, but this does seem like an attempt to ward that off and prevent that kind of immediate analysis or reaction. Of course, if somebody's critical of it, well, have you read the whole report yet? No, of course not. It's 3,000 pages long, or up to 3,000 pages, I guess. So nobody will have read it by the time they start making comments on it on the 30th, which is a Thursday. So some strategic releasing of information here by the Mass Casualty Commission, I would suggest. But that's not going to stop anybody. It's not going to stop me from making an analysis right away. And I've already done an analysis, of course, as regular listeners would know. Released a report of my own, an ebook version, which is called Deficits of Trust. I've also read that ebook here in the YouTube videos and in the podcasts. So people may be familiar with my conclusions. I talked about the emergency alert issue, how, you know, that alert should have been used for an active shooter situation, and that the ability to issue an alert should be brought down to the lowest possible level. In other words, the whoever the supervising officer on scene, even if that is a constable, a low-ranking officer in a sense, but highest ranking on the scene, should have the authority to issue an emergency alert in circumstances like an active shooter situation. So we'll see if the commissioners agree with that, or if they have a different kind of a recommendation. The main recommendation I made, of course, was to replace the RCMP as the de facto police force for Nova Scotia. Of course, we have municipal forces in Sydney, Halifax, other towns, but the RCMP effectively polices most of the geography, at least, if not the population of Nova Scotia, most of the population as well. And my recommendation is that that brand has been so tarnished by the actions and by their reaction to the Mass Casualty Commission, their attempts to cover up mistakes, all of those things, that the RCMP needs to be replaced with a provincial police force. Something tells me that the commission is not going to follow that recommendation. I think they'll have lots of recommendations on policing, but not that broader scale replacement recommendation. The other thing I talked about was a new approach to domestic violence prosecutions. The representatives of different women's groups and others throughout the commission proceedings made recommendations and talked about how the pro-arrest, pro-prosecution policy in the Public Prosecution Service in Nova Scotia and in the criminal code generally prevents many people from making legitimate complaints about domestic violence situations, because it disrupts the family life. It keeps the perpetrator, the guy, usually out of the home when often it's just, the person wants a break of a few hours or a few days, and then wishes to reconcile or to make efforts through counseling or whatever to improve the family situation. But the pro-prosecution approach, which leads to non-contact orders, keeps people away from each other for months at a time while things get sorted out in the courts, is preventing people from making reports because people know that this is going to be the outcome. And final recommendation that I highlighted in Deficits of Trust was the inquiry itself, that the trauma-informed basis of the inquiry was ill-considered, ill-defined and inappropriate given the content that, given the subject matter where, factual issues were in dispute and people were trying to get to the bottom of things. A trauma-informed, to the extent that the commissioners allowed it to be defined, was inappropriate under those circumstances and shouldn't be followed in future inquiries. Well, it's hard to imagine that the commission is going to recommend that the procedure that they themselves followed was inappropriate, but they must by now sense that there were problems with it. And I'll be very interested to read that part of the report when it's released in a couple of weeks' time. Okay, so that's what's upcoming. What we saw last week was the final decision, and there was I think 7 or 8 of these that came out from Judge Halfpenny Macquarie, a well-respected provincial court judge in Nova Scotia that was tasked with handling the issue of the search warrants into Gabriel Wortman's properties. So just as a quick refresher, when the police apply for a search warrant, they need to disclose to the Justice of the Peace or the judge that's authorizing the warrant their investigation and what they've figured out so far. Well, much of that information, some of that information can talk about the ongoing nature of an investigation, if it is ongoing. Sometimes it includes private information about individuals, innocent third parties and others. Sometimes it could talk about intelligence gathering methods. How did the police do this? And, if it's an intelligence gathering, plan that they have or method that they use, and they might want to use it in the future and they don't want to disclose that so that everybody will understand what they're doing, then that can be redacted as well. Well, here we are at the end after the Mass Casualty Commission. So much of the information that was in those ITOs, informations to obtain, was redacted and blacked out, and so nobody could see it. And part of the reason why the Mass Casualty Commission was called in the first place was the reluctance, the reticence of the RCMP and the government to disclose this information. Well, now that the commission has come and gone, the decision from the court has been to release almost all of this information that was blacked out. There is still some innocent third-party information that is not going to be revealed, and that's fine. But the rest of the information, more or less, has been revealed, and without any harm. And so I guess it shows that much of this could have been, much of the delay, the uncertainty, the theories that popped up because of the lack of information, all of that could have been avoided. Much of that could have been avoided, at least, with some upfront transparency on the part of the police and the government. So we'll hopefully the governments and the police forces will learn some lessons from this. Unfortunately, and maybe the courts as well, because one of the unfortunate lessons is that the police were able to actually effectively keep themselves, keep the public in the dark about much of what was going on, and maintain those redactions, that information blackout, for many months, because the court process takes time to unfold with many parties involved and lawyers and scheduling and all those things. So different lessons to be learned here. Hopefully this will be, if whether it's here in Nova Scotia or elsewhere in Canada, if this situation or some kind of situation like this comes up again, that things will be more transparent from the beginning. Okay. Next story I want to talk about. That's so watch for that in a couple of weeks' time. Next story I want to talk about, I'll go through the rest, the other stories a little quicker. That Mass Casualty Commission, obviously the main thing that comes out this week. Next one, though, is an interesting one from Parker Donham. Now, Parker Donham, people of a certain age would certainly be familiar with him from the CBC panels, and everybody was thinking of Parker Donham over the last few weeks with the passing of Jim Nunn, who was the host of the political panel with Parker Donham and Harry Fleming. We used to watch that every week at home, as many people did, I'm sure. I had a chance, actually, one time, think I was still in law school or maybe articling. I was living in the city at the time, and there was a political convention on, and who do I see but Jim Nunn and Parker Donham hanging out, having a drink together, and went and I hung out with them, going from one hospitality suite to another for an hour or more. Very entertaining pair. This was well after, of course, they'd been on television together, but obviously stayed. I don't know how close they stayed, but they had a great time together and enjoyed each other's company there. So it was a special time for me. Anyway, Parker is still very active. He's an instigator, an antagonist, and a public thinker in all the good ways. So this is an issue. He lives in Cape Breton, close to the Seal Island Bridge. Giant bridge, fun to cross over, and a beautiful thing to behold. But it's 60 years old, and it's they had some repair work done to it. I think last summer, the year before, closed down to one lane. So Parker Donham requested from the government under the Freedom of Information legislation for repair plans, studies, briefing notes to ministers about the bridge, see what's going on. Very reasonable requests. In July of 2022, last year, the province noted in their initial response that they had 30 days to respond. In August, they asked for a 30-day extension. After that, Parker asked, okay, geez, at least give me the most recent study. You must be able to get your hands on that quickly. I said, yes, we have the information, but they needed to go through it, make appropriate redactions in their mind, all these things. Okay. So they took more time. Well, here came the problem, because Section 9 of the Freedom of Information legislation talks about extensions. And it says you can get an extension of 30 days or, with the review officer's permission, a longer extension. Okay, what does "or" mean? Was the question that Justice Kevin Cody had to answer. The FOIPOP officer originally said to Parker Donham in a letter that "or" means and/or. It is not a... So this is a great case for English majors. It's not the disjunctive "or." In other words, you get one of these extensions or the other. A 30-day extension requested by the department, or a longer extension with the review officer's permission. If it's going to take so long because there's so much being requested, or any of these things, any of these other reasons, potential reasons listed in the legislation. Well, the FOIPOP officer claimed that "or" means the conjunctive and "or." It could be you get the 30-day extension, and if that's not enough, then you can request longer as needed. And so Justice Cody looked at that, looked at some different legislation. Short decision, though, I must say. Didn't take an extensive look at legislation across the country, but said that it's similar legislation in different parts of Canada. It takes what he calls a purposive approach. Look at the purpose of the legislation. And the purpose was to allow the government the appropriate amount of time to respond. Well, who's to say what the appropriate amount of time is in this case? Seemed like the requests from Parker Donham were reasonable enough, could have been turned around in a month or so with a little bit of dedication by somebody who's on staff to make, to look at those requests. But what Justice Cody says is that the legislation allows for both. In other words, you get that 30 days at the beginning if the department just simply requests it, or if the review officer determines that it's going to be longer, it can be longer. So an unfortunate loss in the instance for Parker Donham. But I'd be very interested. Hopefully he gets the information. He should have it by now, given the length of time that's passed since the original requests over 6 months now anyway, so longer than that. So we'll see what he comes out with, and I'm sure whatever he gets the details, he'll publish something on that. Okay, so that's that case. So if anybody's making freedom of information requests, this will affect, media organizations will be very interested in this. Next case I want to look at is a case that may be of interest to people that buy dogs from breeders. This case, Levesque versus Frazee, F-R-A-Z-E-E. It's a Nova Scotia Small Claims Court decision. And the defendant bought a white German Shepherd dog named Yeti from Levesque, who was a breeder. And the contract, there's two contracts. There was a breeder's just sort of document, but then an actual contract. And the contract talked about breeding Yeti. How, all right, so this couple buys the dog, but the breeder has retained the right to, once or twice a year, bring Yeti back for a breeding session. And the contract also said that the defendants, the owners, had to get permission from the breeder in order to have the dog neutered. Well, the owners found was they did do one litter, and 9 puppies were produced, which was a big litter. And in fact, the Frazees bought one of the puppies. Now, this seemed to have started the problem in 2 ways. One, the Frazees thought they were going to get a puppy for free, given the fact that they had allowed Yeti to go back to be used as breeding material. But instead, the Levesque sold it to them, and sold it to them for $2,600, saying that was a $400 discount because of their position as being the owners of Yeti. Well, Frazees didn't like that, figured they were going to get one puppy for free, and 9 puppies in the litter was quite a unexpected bonus in a sense, so they thought that they deserved that. But the second part of the problem was Yeti became agitated. It became a different dog in a sense, they described, after the litter. The decision didn't get into the explanation of why, although I'm sure there is one. So then they told Levesque, we're going to have Yeti neutered to change his behavior. Levesque said, no, you can't do that. Don't do that. They went and did it anyway. And so Levesque sought damages, sought the $25,000 small claims court limit, in fact. So different claims. One, that he was going to have to get another dog to be the stud dog. And that was going to be $7,000, $8,000. And then the value of each puppy from the litter, $3,000 a puppy adds up pretty quickly. And so in his mind, got up to the $25,000 limit. Well, the adjudicator says no, that doesn't work that way. First of all, the number of puppies that you're going to get in the litter could be 3, could be 6, could be any number within reason. But it wasn't going to be a guarantee, and so that wasn't in there. Plus, there was nothing in the contract that said that, if you neuter the dog, there'd be this amount of damages. The only provision in the contract that allowed was to have the dog returned. And the adjudicator says, okay, well, this dog has been a pet for 3 years. We're not going to send the dog back to the breeder where it's now a family pet. But the value of the original value of the dog, and the Yeti was bought for $1,400. That goes back to the breeder. So the pet owners had to pay back. Actually, it ended up being about $1,700 and some. There was $100 in costs issued, which is the maximum general damages under the Small Claims Court Act, and then $1,400 for the return. Appropriate dog barking in the background, if you can hear that. All right, so that was the dog case. Interesting one with the rights of owners and breeders in that case, and ruled against the breeder, but not nearly the damages the breeder was seeking. All right. Next one I want to talk about, I'll do this. The next two I'll go through fairly quickly. Riparian rights. Okay, so this means if you own a cottage or a property that's on the water, whether it's a lake, whether it's the ocean, whatever, you have the right from any part of your shoreline to access navigable waters. And the converse of that is your neighbor can't block. So this was Laws, it was the woman's name, Ann Laws versus Kevin Wagner and Tracy Brophy on Pond Hook Lake. This is a horseshoe-shaped cove where the two cottages were located. Actually, there was a third one as well, but these were the two that were involved. So the Wagner and Brophy had built a wharf that extended out and interfered with Miss Law's access to navigable water. She liked to kayak, she liked to swim, she did all those things. And so what the court talked about is you have the right to access tidal, whether your waters are tidal, whether there's some receding waters in dry parts of the year, then you still have the right to get into navigable water from any part of your shoreline. And these people had extended the wharf out. Now in the United States, in different parts, there's the right to what they call wharf out, and that is build a wharf as far out as you can to get to navigable waters where you can put a boat in. But here in Canada, that is not the case, and if you build a wharf that tries to get out to deep water, and if that interferes with somebody next to you, then that wharf has to go. And the judge did order in this case that the Judge Josh Arnold, one of the top Supreme Court justices in Nova Scotia, I'm sure got this one right as well, ordered that the wharf be removed and that the rights be respected into the future. So that was any cottage owners thinking about building a wharf, make sure you don't interfere with your neighbor's access to the water. All right, so the last thing I wanted to mention is just a letter that came out. It was an open letter, and it was from different civil liberties associations, the BC Civil Liberties Association, Canadian Civil Liberties, Canadians United Against Hate, International Civil Liberties Monitoring Group, Open Media. There's a dozen or so organizations listed here, and it's all about this planned federal legislation about online safety. And the urging of these organizations is for the government to there's 7 things, and I'll just go through them quickly here. Legislation must not require platforms to issue reports to law enforcement or national security agencies, with the possible exception of content depicting child exploitation or risk of imminent violence. Government must not compel platforms to collect, intercept, or share private communications absent judicial authorization. So a few comments on judicial authorization here. I'll just say that that's can be an issue. As we talked about in the CBC decision earlier, going to the courts or forcing people to have to go through the courts to get things, there's an inherent delay to that. So there would be a problem here too. Should be no requirement that compromises secure encrypted messaging services. Must not mandate short and inflexible timeframes for illegal content takedown unless imminent harm or child exploitation is involved. Must not authorize website blocking except with judicial authorization and opportunity for appeal, and must not mandate proactively monitoring content. Must not create new definitions of harmful content beyond those already established in law. Well, this is something to watch for as this legislation unfolds. There's a lot of pressure in 2 ways. One is, government needs to provide oversight on these online platforms, but the more oversight and involvement the government has, the more that there's a risk of invasion into people's private space. And being an online and your online life world is part of your own persona in a sense, and so you have there's some privacy rights there, and you have to watch for government interference. On the other hand, you must have some government oversight, or else these online platforms, which have don't have a great deal of transparency in many ways, then they'll have the power over us rather than having any democratic accountability to governments. So the civil liberties organizations do talk about that other side of things, and they say Legislation must mandate transparency to the public in how platforms' content moderation systems function. It's a good idea. Legislation must encourage algorithmic transparency for the purposes of research and investigation, and must encourage platforms to create tools that empower users, particularly by giving them the tools to quickly and easily block those they consider bad actors or lock down their own accounts. Well, it's using your own accounts. You should have that right, certainly. And then finally, standards of conduct placed on platforms should focus on patterns of behavior based on reasonable risk assessments. A standard of perfection where any mistake is subject to a penalty is not workable or realistic, and that's certainly true. You got to have a system in place with oversight and accountability, and then be answerable to democratic governance systems as well. So we'll be watching for that as that unfolds on the federal level, and if any of the provinces are looking to do that as well. So different things we're thinking about this, or I was thinking about this week, and I'm sure there'll be more to talk about on some of those topics, and we're watching for other cases next week. Some other situations coming up as well, I'm sure, and we'll be anticipating over the next couple of weeks the Mass Casualty Commission report, certainly. And I'll be talking about that when it comes out. And I'm anticipating doing a public session with Jordan Bonaparte and his nighttime podcast platform in Halifax at some point soon after that report release. So watch for all of those things. And in the meantime, thank you for watching and thank you for listening. And we'll see you next time.